My name is Gary Bunce. I'm a partner and head of the residential conveyancing team at IBB Solicitors. There are certainly ways that a seller and a buyer can speed up the conveyancing process. For a seller, one of the things I would advise is to contact the solicitor early, before the property is even put on the market. This is important in certain areas, especially Buckinghamshire, where there are lots of unregistered title deeds. So if you contact the solicitor, they have that opportunity to investigate the title fully and collate any ancillary documents needed, such as property forms, fixtures and fittings forms, under a system called Protocol. Contracts packages with the title can be sent out immediately as soon as the buyer has been found. So this investigation and time spent at the outset will end up saving you probably a week or two, or even longer if there were title issues. For example, sometimes we might apply for first registration of the title. For a buyer, especially a new client to the solicitor, again, it's a good idea to get in touch so matters such as identification procedures and due diligence can be sorted out at an earlier stage. Prudent buyers will instruct a solicitor before they have found a property and will look organised from the seller's point of view. Good communication throughout the transaction will help speed up the process amongst the clients, solicitors, estate agents, surveyors and mortgage lenders. The key is to try and keep the transaction as transparent as possible. Exclusivity agreements are very popular in a seller's market, particularly in the West End of London. It is an agreement between the seller and buyer made at the offer stage. Typically the buyer, not the seller, will pay a deposit, and it's an attempt to secure the sale effectively. In return, the seller removes the property from the market for an agreed period of time. This means for the buyer they have the opportunity to offer to buy the property within that agreed period. It is most important to realise, however, that these agreements only buy a period of time. It does not compel the seller to sell the property or the buyer to buy the property. Both the sellers and the buyers will have to be carefully advised before entering into an exclusivity agreement. It is a common mistake to think this will secure the transaction. Special consideration in drafting should be made. For the buyer, they need to know that they are able to withdraw from the transaction and keep their deposit because of an adverse survey or legal issue, for example. For the seller, they will want to see that they can keep the deposit if the buyer fails to perform their obligations under the agreement. Be warned that clients, especially buyers, are asked to enter into these agreements without any involvement of a solicitor from time to time, which is extremely dangerous, and you could lose the deposit and the property. The difference between exchange of contracts and completion is at the exchange stage, identical contracts are exchanged between both party solicitors, making the property transaction legally binding. Completion is effectively the moving day, and the day the buyer takes possession of their new property, and the contract is substantially concluded at that point. Completion is set at the exchange of contracts stage and is typically 2 to 3 weeks from that time. If a party tries to withdraw after exchange of contracts, that party would be in breach of the contractual terms and liable to the other party for such damages as contractual interest and reasonable damages under common law remedies. Damages can include removal costs, storage costs, and damages from other transactions in the chain that have also been delayed as a result of the defaulting party. So, once contracts have been exchanged, the parties have confidence about the completion date and they can book removals, arrange building insurance and service media arrangements. An energy performance certificate is effectively an energy rating for the property introduced by the government. Estate agents cannot market a residential property without the EPC, as it is commonly known. There has been further development in this area with the introduction of Green Deal loans. Green Deal loans are taken out by the owners to implement energy-saving measures, such as installing solar panels, double glazing and more economical and efficient boilers. Buyer solicitors will want to investigate whether there is a Green Deal loan because, in my view, the loan is effectively hidden in the energy bill. Interest rates for these loans can be 7% or even higher. From the seller's point of view, it is a way of having energy-saving measures implemented, and perhaps make the property more attractive to a buyer. But the buyer needs to be aware the energy bills will be higher. Buyer solicitors will ask for those loans to be repaid. As a result, most sellers locally do not take up these Green Deal loans. If you would like to know more about the residential conveyancing process, then please contact me, Gary Bunce, or one of the members in my team at IBB Solicitors.